बढ़िया।
नहीं, इस तो मेरी मतलब 4 साल तो बिटिया की शादी भी हो गई मेरी।
वाह
टाइम हो
क्या
गया
बात है सर, सीरियसली लगता नहीं है कि आपकी इतनी बड़ी बेटी होगी।
So now, good afternoon, all the participants, and welcome to this 5th day of web series on basics of international taxation. And we are again welcome with this series, and I welcome C. Anshul Singhal ji, the speaker for the days, and he has drafted the complete series. And the moderator of the session, Piyush Sharma ji.
Thank you, ji.
Today we will read about Article 6, Article 8 and Article 9. से पहले के आर्टिकल्स हम सारे रीड कर चुके हैं, उसकी प्रेजेंटेशंस एंड वीडियोस भी सभी पार्टिसिपेंट्स को भेज दिया गया है। पार्टिसिपेंट्स अभी भी हमारे साथ में 16 पार्टिसिपेंट्स ही जुड़े हैं अंशुल जी।
20 हो गए, बढ़ रहे हैं
20 एक्चुअली में, तो आई थिंक वी शुड वेट फॉर अनदर 2 or 3 मिनट्स।
हाँ जी, हम वेट कर लेते हैं। इतने में मनोनीत जी से भी पूछ लेता हूँ कि मनोनीत जी आ गए हैं कि नहीं आ गए।
मनोनीत जी आ गए। मनोनीत जी प्लीज कीप योर वीडियो ऑन एंड अनम्यूट योरसेल्फ।
हाँ जी, नमस्ते।
नमस्कार जी,
कैसे हैं?
बस जी।
आप खुद वीडियो बंद करके बैठे और मैं से ऑन कराने की बात कर रहे हो।
नहीं खुली तो हुई है उनकी वीडियो,
खुली हुई है।
वो 2 लॉगिन आईडी से हैं सर, वो डबल अवतार में है।
एक्चुअली सर आप मोबाइल से ना, तो मोबाइल से एक ही नजर आता है, दैट इज द इशू, सेम विद मी। तो स्क्रीन पे सबके चेहरे देखने के लिए और वो
मेरे को भी डबल लॉगिन से आईडी वो लॉगिन करना है। मैंने सिर्फ अभी इसलिए नहीं करा, मैं कहा जब एक बारी प्रेजेंटेशन शुरू करेंगे तब करेंगे, बिकॉज़ यस अननेसेसरी तो जूम कंफ्यूज हो जाता है कि क्या हो रहा है।
तो वैसे बट हमारा ये सेमिनार, ये वेब सीरीज जो है ना सर, बढ़िया पूरा नेशनल है। वैसे तो इंटरनेशनल टैक्स के ऊपर है, बट पूरा नेशनल लेवल से जुड़े हुए हैं
सर। हमारे साउथ से, बॉम्बे से, कलकत्ता से।
हाँ, मनोनीत जी देखो पंचकुला से, और इसमें हमारे पास वडोदरा से भी हैं 3-4 पार्टिसिपेंट्स, मुंबई से भी हैं।
एक्चुअल टॉपिक बहुत ब्रॉड है, टॉपिक इंटरनेशनल लेवल का है, तो आई थिंक ऑल ओवर द वर्ल्ड पीपल शुड लर्न दिस।
एब्सोल्युटली गुड सर।
मनोनीत जी कहाँ से हैं?
पंचकुला से सर,
चंडीगढ़ जी, बट आज
पंचकुला से।
हाँ, पंचकुला में हूँ। हाँ जी,
पंचकुला सेक्टर, पंचकुला
सेक्टर 11 से।
ओके, सेक्टर 12 में मेरी सिस्टर रहती थी पहले लास्ट ईयर।
तो मनोज जी, पंचकुला में इंटरनेशनल टैक्सेशन का कैसा स्कोप है?
पंचकुला में ऑनलाइन तो सब जगह पूरा स्कोप है।
पंचकुला में आई थिंक बद्दी से क्लाइंट काफी आते होंगे, बद्दी हिमाचल पास पड़ता है।
नहीं सर, मैं बताता हूँ आपको थोड़ा सा पंचकुला का स्कोप। पंचकुला का स्कोप आज की डेट पे बहुत ज्यादा बढ़ चुका है, और मनोनीत जी हमारे जो है वो एडवोकेट हैं।
अच्छा,
और ये बिग फोर्स में काफी काम कर चुके हैं, ईवाई में, डेलॉयट में, केपीएमजी में। केपीएमजी में थे? नहीं, केपीएमजी में नहीं थे।
केपीएमजी में भी रहा हूँ मैं 1 साल।
अच्छा, रहे हो 1 साल
पहले 1 साल, हाँ जी, 2004 से 2005 केपीएमजी में था।
हाँ जी,
फिर 2005 से लेके मैं 2014 तक ईवाई में रहा हूँ, जिसमें मैं शुरू के 4-5 साल ईवाई में एज ए सैलरी रहा हूँ, उसके बाद ईवाई में रिटेनर रहा हूँ एज ए एडवोकेट। तो मेरा एक्सपीरियंस ट्रांसफर प्राइसिंग, इंटरनेशनल टैक्स का
पंचकुला में तो हमारा भी काम काफी रहता है।
हाँ, पंचकुला में मैं आपको थोड़ा सा वो बता रहा था कि स्कोप कैसे है।
स्कोप बता रहे थे।
स्कोप इसलिए है सर क्योंकि पंचकुला इज जस्ट एडजेसेंट टू चंडीगढ़, और चंडीगढ़ में पंजाब एंड हरियाणा हाई कोर्ट लगता है हमारा। और आज की डेट पे सर गुड़गांव इज दी हब फॉर इंटरनेशनल ऑर्गेनाइजेशंस, एमएनसीज, मतलब भर भर के गुड़गांव में बैठी हैं। और गुड़गांव की इनकम टैक्स ज्यूरिसडिक्शन जो पड़ती है वो चंडीगढ़ पड़ती है। तो उनके जितने भी केसेस जाते हैं वो दिल्ली हाई कोर्ट ना जाकर के चंडीगढ़ हाई कोर्ट जाते हैं।
एग्जैक्टली, एक्चुअली मैंने काफी काम किया पंजाब हरियाणा हाई कोर्ट का ना। बिल्डर्स का जब ये हरियाणा में प्रॉब्लम चल रही थी तो करीब हमने 30-35 रिट्स फाइल कराई थी वहाँ। तो लक्ष्मण कुमारन के साथ लेके की थी, फिर सुप्रीम कोर्ट में हरीश साल्वे साहब के साथ काम किया काफी। तो उस टाइम भी यही था कि पंजाब हरियाणा का जितना भी काम था सब चंडीगढ़ और पंचकुला से होता था, और अब धीरे धीरे मोहाली डेवलप हो रहा है।
हाँ जी,
अब मोहाली भी डेवलप हो रहा है,
मोहाली भी काफी डेवलप हो रहा है।
और उस रीजन में ना बहुत ज्यादा टेक्निकल एक्सपर्टीज वाले लोग कम हैं।
हाँ जी,
जीरकपुर भी काफी हो रहा है,
जीरकपुर भी हो रहा है।
हाँ जीरकपुर।
तो मैंने तो वर्क्स कॉन्ट्रैक्ट का और सर्विस टैक्स का एंटीवेजन
अंशुल जी, now I think we
पंचकुला में और अपील
we can start. 25 participants जुड़ गए हैं।
हाँ जी, हाँ जी,
Anshul,
मेरे ख्याल से हम शुरू करते हैं सर।
Yes, yes. I request you all participants, please mute your speakers. We can start, Anshul.
Yes.
Thank you everyone, thank you for your participation today. Actually हमने weekend पे course रखा है, तो it's always difficult to join in on a weekend, but it's good to see at least 25 participants have still been able to join today. And today's our topic will be Article 6, which is income from immovable property, Article 8, which is income from shipping and inland waterways and air transport, and then we will be discussing Article 9, which is on associated enterprises, and primarily it is transfer pricing article which caters to the transfer pricing rules and regulations. So I will be taking you through Article 6 and 8, and my co-speaker Manoneet Dalal, he will be taking you through the Article 9. He is a transfer pricing expert with experience of more than 15-16 years. He has worked with Manoneet ji has worked with Deloitte, Deloitte EY and KPMG for a long time, and he has been representing the clients before tribunals on the transfer pricing matters as well as international taxation matters. So with this background, let me start our today's presentation. So as we discussed that we will be discussing two broad articles. Just to give you background of these two articles are not generally used too much. These are not frequently used in Indian perspective, more or less, because immovable property, in the sense that foreign enterprises are not freely allowed to occupy immovable property within India, and therefore more of the multinational companies, they cannot directly own immovable properties in India. Similarly, investment in immovable properties outside India is also a little bit restricted. So you don't see too much of this, but most of what happens is many times the Indian expatriates who have been living outside of India for their employment or for their businesses, they acquire properties outside India, and when they come back for their businesses into the Indian territory and they become residents, at that point of time, this kind of this article is used many a times. And also it is used inversely, because then you are saying that the income can be taxed in outside location also. So we'll read what is the paragraphs, how it is mentioned in OECD Model Convention and how it is mentioned in UN Model Convention, and then we will see how the taxation happens. So first of all, first thing first, let's read what is the text, bare text of OECD Model Convention. So Article 6, 1 and 2 reads, income derived by a resident of a contracting state from immovable property, including income from agriculture or forestry, situated in other contracting state, may be taxed in the other state. Now reading it in the Indian context, say for example, an Indian resident, he was owning properties in India, but he has gone outside of India and settled there for businesses or for employment purposes, but he continues to derive income from the immovable property in India. So how would we read it? Income derived by a resident, say for example, the person has gone to UK, income derived by a resident of UK from immovable property situated in India may be taxed in that other state, means may be taxed in India. So if the immovable property is situated in India, then India has got the taxation rights over this income which is generated out of the immovable property. So this is the first and foremost article, paragraph of Article 6. Then it goes on to say, the term immovable property shall have the meaning which it has under the laws of the contracting state in which the property in question is situated. So immovable property is not specifically and independently defined in Article 6, it leaves the definition to the laws of the contracting state in which the immovable property is situated. Now, why this is happening so is because immovable property is invariably linked to the economic connection as well as the legal connection generally lies with the place or the contracting state where this property is situated. Therefore, it is said that immovable property should best be left to be defined by the contracting state in which that immovable property is situated. Now, it goes on to say, the term shall in any case include property accessory to immovable property, livestock and equipment used in agriculture and forestry, rights to which the provisions of general law respecting landed property apply, usufruct of immovable property, and rights to variable or fixed payments as consideration for the working of, or the right to work mineral deposits, sources, or other natural resources. Now there is a semicolon after this, and it says ships, boats, and aircrafts shall not be regarded as immovable property. Now, reading the first part first, that any kind of mineral resources or any kind of rights or any kind of equipment or livestock, whichever is linked or whichever is connected with the immovable property, the same is also conceptualized to be covered within the definition of immovable property. Now it can be your various kind of equipments, your agricultural equipments, your assets which are related to your immovable property, or say for example if you are doing agriculture on a land and if you give the agricultural rights to somebody else and you derive a proper rent or say some usage charges out of transfer of those right to agriculture, even those kind of incomes are covered under this particular article, and it will be taxable in the contracting state in which that immovable property is situated. Say for example, if you have a building in another contracting state and you just give the rights to sell that or give the rights in that particular property in any kind of way, even the right income derived from those rights shall be taxable in the contracting state in which that immovable property is situated. Now at the end of it, it says that ships, boats, and aircrafts shall not be regarded as immovable property. I'm not pretty sure why it is mentioned here, because ships, boats, and aircrafts are in any ways not immovable property. They are movable things. But as the case it is mentioned in OECD Model Convention as well as in OECD Model Convention. But there is a little difference. The term boats is not mentioned in UN Model Convention. So all the other part of Article 6.1 and 6.2 are same. It is exactly word by word same in OECD Model Convention as well as UN Model Convention, but only the term boats is missing in the UN Model Convention. Now, one logic which goes behind it is that boats is generally smaller water vehicles, water vessels, which are used in the inland waterways within the rivers or within the territories of the country, whereas ships are larger vessels and are generally used in international traffic. So in OECD, the inland water transport is also in a way tried to be covered under Article 8, which we will be reading later on. Whereas in UN Model Convention, the only thing which is covered or which is generally, they are distinguishing between boats and ships. So that might be the reason, but as such in the commentaries or anywhere in the material, reading material, we do not find why this boat term is missing in UN Model Convention. So some of the important principles related to Article 6 are that the first and foremost primary right of taxation is granted to the source state and not to the resident state. Resident means the owner of the property, wherever he is resident, does not have the primary right to tax the income from immovable property, but it is the source state where the property is situated which gets the first right to tax the income. Further, there is no specific mechanism provided in the Article 6 which says that how to compute the taxable income. So what does it mean is that the mechanism has been left on the source state that they can draft their domestic tax laws on how to compute the taxable income and in what manner they would tax the income. So in other articles, if you would see that there is a rate prescribed in Article 10, they will provide that the dividend should be taxable at particular rate. In Article 11, interest should be taxable at particular rate. In Article 12, fee for technical services or royalties should be taxable at the particular rate of 10% or 15%. Whereas in Article 6, there is no rate prescribed. So highest rate can be applicable as per the domestic tax laws of the source state. Moving further, the scope of Article 6 also includes income from activities that constitute agriculture or forestry. But as we know that from an Indian standpoint, agriculture and forestry by foreign enterprises is not permitted under the FDI regulations, and therefore this is not generally used. And also in the Indian DTAAs, it is used somewhere and somewhere not. So you will not find agriculture and forestry to be covered in all the DTAs. It is not a generic term which you will find everywhere. So moving on, other rights, assets, equipments, we have already spoken about that. Even if these kind of assets or rights which are related directly or indirectly to immovable property, if these kind of assets or rights yield certain income to the non-resident, then that particular income shall also be taxable in the source state as per the laws of the source state. Then Article 6 does not specify anything about the rights of the resident state. So if we go back to the taxation rights, we have discussed in Article 1 and when we were starting this course that double taxation avoidance agreement is generally entered into to allocate the taxation rights regarding a particular stream of income. Now in this particular article, what happens is that it talks only about that the other contracting state may tax the income from immovable property. Now if you would read, when we will go further and we will read Article 10, 11 and 12, you would find that it starts that the income derived shall be taxable only in the state in which the enterprise is a resident. The first paragraph says so, and then in the second paragraph it generally mentions that the income may also be taxed in the state in which it arises. So therefore in those articles there is a bifurcation of taxation right between the source state as well as the resident state. But here in this particular article, in all the treaties, invariably you will not find any mention of the taxation rights of the resident state, and that became a controversy in the Indian judgments. We will come on to that when we come to some case studies. So this was something which is relevant and which was taken note of by the Indian courts. And due to that fact that there was no clarity in the double taxation avoidance agreements, and it only said that it may be taxed in the source state, the Indian government came up with a notification which was 90 and 91. 90 and 91 are two notification because there are two kinds of tax treaties where we are entering into a treaty with a sovereign country, and there are certain specified territories also where we can enter into tax treaties. So in both the cases, wherever we have treaty with sovereign state, central government of that sovereign state, or a jurisdictional authority of a specified territory, both these things are covered under 90 and 91. It is of 2008. It says that wherever the DTAA provides that an income may be taxed in the source state, then it shall also be included in the income of the Indian resident for taxation purposes in India. So what does it mean is that in government clarified that it does not mean that maybe tax means giving the sole rights to the foreign territory itself. Then there are certain Indian section also. I've just mentioned it for reference purposes. Sections 269 UA, it defines land and property. Land or building or part thereof includes plant, machinery, furniture, fittings, and other things transferred along with land or building, and including the rights thereof, as we have read in the treaty also. It is a similar kind of thing. Then there is definition of immovable property in 194 IA also, which says land or other agricultural land or any buildings or any part of the building, they are considered to be immovable property. Now, I've already discussed that immovable property is not defined in the DTAA. It has to be read as per the laws of the domestic tax law of each of the states. Means when we are referring to India, we'll refer Indian tax laws. Or if Indian resident has a property in some other country, then we'll look at the domestic tax laws of that country. In the DTAA, it is generally defined only in an inclusive manner rather than an exhaustive manner. Now, there are two case laws on this particular study, this particular article, which are very important. One is of R.M. Muthaiya. It is of old judgment of 1993, wherein it was dealing with the case where the Indian resident was having an immovable property in Malaysia, and it was argued by the taxpayer that when I am having a property in Malaysia on which I am paying tax in Malaysia, and as per Article 6, it only talks about the taxation rights of the source state, and it does not specify anything about the taxation rights of resident state. That means invariably the taxation right has not been granted to the state of residence. Means India does not have a right to tax this income, and means interestingly, the Karnataka High Court accepted that position, and it was mentioned, it was observed that in the instant case, the result of this clause is this Article 6.1, was that income from immovable property in Malaysia might be taxed by the government of Malaysia. When a power is specifically recognized as vesting in one, means they are saying that the power of taxation has been vested in one of the governments. Exercise of such a power by others is to be read as not available. Means once a power has been granted to the Malaysian government, you cannot automatically take some powers back to the Indian government, draw some powers without any specific mention in the treaty. Then such a recognition of power with the Malaysian government would take away the said power from the Indian government. The agreement thus operates as a bar on power of the Indian government in the instant case. This bar would operate on Section 4 and Section 5 also. So this was the case, and this was the case which was followed later on also in some of the rulings. And in PVAR Kulandagam Chettiar, which we discussed in second session when we were talking about some notifications coming into the Indian law, and when we were discussing Article 3, where general definitions are there, and we had mentioned and we had discussed that whatever definitions are not defined in the tax treaty, they should be taken color from the provisions of the domestic tax law. Now, maybe taxed is a term which is not defined anywhere in the treaty. So what did the Indian government do was, they brought up notification 90 and 91, which we discussed on the last slide, that it said that whenever in the treaty it is mentioned that the income may be taxed in other contracting state, then the income shall also be liable to tax in India in the hands of the resident of India. So citing that ruling, another case of Shah Rukh Khan came up, wherein after the notification number 1991 were already in place, the court now held, the Mumbai tribunal now held that it is very clear, the position of law is very clear, that whatever income is taxable outside India from an immovable property. So Shah Rukh Khan had a villa in Dubai, out of which he was earning certain income, certain rental income, and he had not offered this to tax, citing the same principles of law that may be taxed mean the taxation right are only with Dubai and not with India. But the tribunal held that after the notifications have been brought in, may be taxed only means that it may be taxed in foreign location, but it has to be taxed in India also. And therefore the position was negated, and it was held that any income from immovable property should be taxable in India also. Now, I would mention that even though there is one ruling, but there are not too many rulings on this aspect. And as of now, also some of the practitioners do take a position that Shah Rukh Khan ruling is only a tribunal ruling and not a high court ruling or not a Supreme Court ruling. So therefore, many people are still trying their luck by saying that by bringing in a notification, you cannot alter the taxation rights of which are being granted by the domestic by the DTAA. So what does the position, what does the alternate argument say is that may be taxed, you may say that it is giving only a certain rights to the source state, but as per the treaty there is no bifurcation of the no allocation of the taxation right to the resident country, whereas there are other articles where specific rights allocation has been done to the resident country. So if the sovereign countries were of the view that the taxation right should also be granted to the resident state, then there would have been a specific provision in the double taxation avoidance agreement, and in absence of that provision there should not be any alteration in the tax position just by bringing two notifications in the domestic tax law. So that is what the position is going in the circles of tax practitioners, and the opinion is divided as of now. There is no Supreme Court ruling on the changed position, and therefore I would say that if the alternate position is taken, one should be ready for litigation, because that particular position will not be upheld by the AO at the assessment stage. So therefore we must be careful while dealing with such kind of situations where Indian resident is having residential property outside of India. Now this is somewhere, this kind of cases can arise in two situations, wherein one person who was outside of India, residing outside of India, he acquired properties and then came back to India because it's the native place, and now he keeps on holding the foreign properties and earns income from India. It can also arise in cases where there are expatriates who have come to India for a longer duration of time, say for example 4 to 5 years of deputation, and in the third to fourth year they will become ROR, the resident and ordinary resident of India. In those circumstances also, if they are earning any income from their immovable property situated outside of India, then also you might need to consider the provisions of Article 6. Right, sir? I think we should move on now. Article 6, 3 and 4, these are very generic paragraphs. It says that provisions of paragraph 1 shall apply to income derived from direct use, letting or use in any form of immovable property. Very simple provision. Then it says provisions of paragraph 1 and 3 shall also apply to the income from immovable property of an enterprise. Means, what is the difference between property of an enterprise? Means it says that the interpretation which can be derived out of this is that the para 1 of Article 6 talks about income from immovable property and does not talk about whether it is owned by the enterprise or not owned by the enterprise. So even if they are earning certain income from immovable property which is not owned by the enterprise, foreign enterprise, even that income shall be covered under Article 6(1). And Article 4 says that even if the enterprise owns the immovable property, that should also be covered. So there should not be any confusion, and therefore it mentions so. In the UN Model Convention, paragraph 3 is same. Paragraph 4 says provisions of paragraph 1 and 3 shall also apply to the income from immovable property of an enterprise and to the income from immovable property used for performance of independent personal services. Now, independent personal services means persons who are individuals or firms or a association of individuals who are using the premises in a source state to render their own services, and if they are in the course of it earning certain immovable property, then also the income shall be taxable in the source state. So other than this, in the UN model commentary also there is not too much of elaborate commentary available on these two articles or these two paragraphs, and therefore these are not too widely used. Even in the case of independent personal services, if they are using the property, probably they will not be earning income from immovable property, but they will be earning income from the rendering of services. So that is how we should read it, and it is very few circumstances you will find this case to be applicable. Any questions as of now? We'll move on to the next article. Is there any question? Yuji, is there any question as of now?
No question in chat box. We can move on.
Okay, great. So coming on to shipping, inland and waterways and air transport, this is also a small article, but a very interesting article. And UN Model Convention and OECD Model Convention are quite different in their wordings and coverage of what they try to cover. So we'll first read OECD Model Convention. Paragraph 1 says, and mind that Article 8 is this one only. So what I have mentioned on this slide, in OECD Model Convention, Article 8 is just this one, 4 small paragraphs. What does the first paragraph say? Profit from operation of ships or aircrafts in international traffic. International traffic is very, very important. Shall be taxable only in the contracting state in which the place of effective management of the enterprise is situated. Right? Now, ships and aircrafts are operated by certain companies or certain organization. What does it say is that whosoever enterprise is operating that ship or aircraft, wherever the place of effective management of that ship or aircraft managing enterprise is situated, the income shall be taxable only in that state. Means you would see that various airlines or various shipping companies operate through India. You would be booking tickets with British Airways, Emirates, Thai Airways. So many international airways do operate in India, but they are operating only in Indian international traffic. So if you would see carefully, you will never be able to book ticket on Thai Airways from Delhi to Mumbai, or in that sense for British Airways from Delhi to Mumbai or Delhi to Kolkata. That is what my understanding says. They will never operate in domestic traffic. They will always operate in connecting flights. Even if you will be, they will be stopping in between, but only for picking up passengers rather than to drop them. So, for example, if a flight starts from Kolkata to Delhi to London, the pure persons who have boarded the flight in Calcutta would not be able to deport in Delhi. That is what my understanding says for the international flights. Because if that happens, that will become domestic traffic rather than international traffic. And it will be very difficult for these international airlines to segregate the revenue from domestic traffic and international traffic. Also, to my mind, as per my knowledge, these international airlines do not get a license to operate in domestic traffic.
Anshul,
So, yeah.
I have one question. Can I take?
Yes.
Vistara Airlines is the joint venture of Tata and Singapore Airlines. So if they are operating some fleet size from India, some from Singapore, so in that case, what we call this operation of aircraft?
See, this Vistara is an Indian company, even though the shareholding might be with some other companies, but
Yes.
the enterprise is Vistara, which would be the Indian company.
Yes.
Now, whatever fleets they are operating, they would be considered to be the enterprise. The traffic will be of India, will be considered to be in India only. And all the income which Vistara will earn will be taxable only in India.
If some fleet size in Singapore.
See, fleet size, they cannot permanently, I don't think that fleet size will be permanently based in Singapore.
Okay.
I need to check that
I
fact.
think I can answer that. So
Yeah.
So I think so. What's really happening in the Vistara is a typically Indian-owned joint venture.
Yeah.
And there was a typical condition that even an Indian company which has spent 5 years, only then they can actually fly the internationally. That's the reason you will see that Vistara has started flying to Singapore and other countries now after 5 years. So though they have a tie-up with obviously a Singapore company base, so they have a tie-up, right? So whenever international flights are considered, so as a passenger you will not know. Okay, so for example, the KLM and the French airlines used to have a tie-up.
Yeah,
So
KLM.
similarly, it's a tie-up between Vistara as well as the Singapore Airlines. But Vistara per se has started operating international operations because they have now completed their mandatory period of 5 years. Okay, so it's a completely separate Indian entity in that sense. Though they have a funding from it's more from an operational perspective and a funding perspective, they have tie-up with the Singapore Airlines.
See, Piyush, what happens is that the company, whichever is operating in international traffic, they will have flights But always what will happen is that their base location will be the country of their origin only.
Okay.
Right? Wherever they will fly out, they will come back to India only. Right? Say for example, for British Airways, wherever they will fly all over the world, the base location will always be England, UK. So that's how the companies operate, and I have dealt with the assessment of one or two airlines companies. It is very clear, even though they have license offices in India, all these foreign companies will have license offices in India. They are engaging in ticketing, they are engaging in various kind of, Emirates has a license office. I think they have offices in India. Thai Airways have an office in Nehru Place. They have a big office if you would go there. So they have license offices in India, and they have multiple license offices. I mean, they have multiple branches in India. Even then, the P clause will not trigger. Even though they are taking, soliciting businesses, they are booking tickets, which we read in the last session. Even then, because Article 8 is the specific article, and we had read that even wherever there is a specific article dealing with a particular stream of income, the income needs to be dealt with in that particular article only, and that will not go back to P article unless and until it is specified therein. Right? Say for example, in Article 12 or Article 11, it is mentioned that if you earn interest or fee for technical services, which is effectively connected to the P, then they are again direct you back to Article 7. So in those particular circumstances, the income of airlines or shipping companies which are only operating in international traffic does not get taxed in the source states, but it will only get taxed in the state in which their place of effective management is situated. Also, in some of the treaties in relation to the ships, you would find that it is mentioned in some of the treaties, it is mentioned that whichever country's flag the ship bears, it will be taxed there. Because in international waterways, it is very important for a ship to carry a flag.
Yeah, exactly.
Right? A flagless ship is, too prone to be attacked by anyone. So generally, all the ships carry a flag. That means that they carry a nationality. And in some of the treaties, you will find that whatever country's flag the ship is carrying, the income will be taxed in that country only. So there are different kind of ways where it is mentioned, but whatever is the situation, 99% of times you will find that source state does not have the right to tax such income.
Okay.
Right? Now, place of effective management is another concept which you find in the domestic tax laws also, right? And place of effective management, as per domestic tax laws and as per international tax parlance, it is said that place of effective management can only be at one place. There can be multiple places of management, but place of effective management can only be at one place. So there are different separate set of rules and regulations providing the guidance as to how to determine the place of effective management, but that is not the topic which we are discussing today. So moving on to the second paragraph, it says profits from operation of boats engaged in inland waterways transport shall be taxable only in the contracting state in which the place of effective management is situated. It also says so. Now, what we are discussing from day one is that OECD is always protecting the rights of the resident state, right? So even if the ships are engaged in inland waterways, there are many landlocked countries wherein you are connected by lakes or canals or rivers through to the sea channels. And if through the rivers you are moving on to the inland waterways and you are doing certain businesses in the inland parts of the country itself, even then OECD says that it should not be taxable in the source state but only be taxable in the country where the POEM is situated. But as we will move on to the UN model, you will not find this. Inland waterways is generally not covered in the Indian treaties also. Now, on paragraph 3, it says, if the place of effective management of a shipping enterprise or of an inland waterways transport enterprise is aboard a ship or a boat. Now, what happens is they are giving certain, conditions. Say, for example, if a shipping enterprise does not operate on a land, means the entire management of the ship is based on ship itself. They do not have any place of business in any of the countries. then how would you determine the place of effective management? Now, place of effective management is aboard a ship or a boat, then it shall be deemed to be situated in contracting stage in which the home harbor of the ship or the boat is situated. Matlab, wherever your home harbor is situated, you will tax the income there only. Or if there is no such home harbor, in the contracting stage in which the operator of the ship or a boat is a resident. Means wherever the person who is managing the ship, who is the owner or the manager of the ship or the operator of the ship, wherever that person is resident, only in that country you will tax it. But what will happen in these kind of circumstances, if a place of effective management is generally on a ship, then it might happen that the person operator is also sitting on the ship, and once the operator is shipping on this ship, it might happen that that person or that operator is not a resident in any of the countries, because we had read in the article 4 wherever the residency is defined that you need to be situated in that particular land or the jurisdiction. If it is an individual who is operating it, you will need to have presence of certain defined days, 182 days, or certain other criteria you'll have to fulfill to become a resident in a particular country. Similarly, for a company to be a resident, either it has to be incorporated in that location, or the place of effective management has to be located in that jurisdiction. So once there is a body corporate who is managing the ship, you might say that wherever that enterprise has been incorporated is the country of residence, and therefore the taxation can happen accordingly. Now, moving on to the fourth paragraph, it says provisions of paragraph 1 shall also apply to profits from participation in a pool, a joint business, or an international operating agency. So what you will find is that for operation of international traffic, you will have associations, the International Association of Transport, or International Airlines Transport Association. So you in shipping also you'll find some international associations which facilitate the businesses international traffic. So if you are driving certain incomes from those organizations or participating in a pool of such activities, even that is slated to be exempt in the source state and only taxable in the state of the resident of the enterprise. Now this was OECD Model Convention. Now we'll move on to Article 8 of UN Model Convention. This is alternate A. UN Model Convention gives two alternates of Article 8. Now what happens is we have studied and we have discussed that model conventions are only providing you guidance. You are providing you reference that how you can draft your treaties, how you can negotiate, and what principles you can bring in your tax treaties. So alternate A is very small. It says that profits of an enterprise of contracting state from the operations of ships or aircraft in international traffic shall be taxable only in that state. Now you would see the difference between OECD and UN model is the UN model convention does not talk about place of effective management. It merely says profits of an enterprise of a contracting state. That's it. Shall be taxable only in that state. So there is quite a lot of difference. So even if place of effective management might be somewhere else, but if your enterprise belongs to a particular country, the taxation will happen only in that country. Now in second paragraph it says the provisions of paragraph 1 shall also apply to profits from participation in a pool or a joint business or an international operating agency. So this is similar to what we have seen the last paragraph 4 of OECD Model Convention. Now coming on to Article 8 of alternate B in UN Model Convention. Paragraph 1 is same. It does not talk about place of effective management. It merely talks about profits of an enterprise of a contracting state shall be taxable only in that state. But it also talks about international traffic, right? It does not talk about inland waterways. As we had seen, it was, the OECD model was also covering inland waterways, but in UN model, there is no inland waterways. Now in paragraph 2, it is an important paragraph, means it goes beyond certain things. Generally, you will not find it in the Indian context, Indian treaties, but let's read it. Profits of an enterprise of a contracting state from operation of ships in international traffic shall be taxable only in that state. Now you would see that it is only talking about ships. It is not talking about airlines. So airline traffic is only covered in paragraph 1. So in paragraph 2, we are only discussing ships. Ships in international traffic shall be taxable only in that state unless the shipping activities arising from such operations in the other contracting state are more than casual. Now, what does it mean? More than casual means that if you are operating on some excessive basis, you are going beyond casual things. Now, this is very generic and very subjective thing. More than casual is not defined. It is up to the interpretation to be drawn by the contracting states, and that's why we see that generally these type of clauses are not mentioned in the DTAAs. So it is found in the UN Model Convention, but you will generally not find these terms in the actual DTAAs which have been executed. Now it further goes on to say, if such activities are more than casual, such profits may be taxed in the other state, means the source state. Therefore, if the activities from operation of ships in international traffic are more than casual, then such income can also be taxed in the source state. Then it further goes on to say, the profits to be taxed in the other state shall be determined on the basis of an appropriate allocation of the overall net profits derived by the enterprise from its shipping operations. This is basically nothing but transfer pricing, that you will allocate the profits. Then the tax computed in accordance with such allocation shall then be reduced by a particular percentage. It says that we will reduce the total profit percentage by a certain percentage, which shall be decided and negotiated by the contracting states while finalizing the tax treaty. Now this is very interesting and very different kind of thing, which generally we do not find, but I have discussed because it is there as part of UN Model Convention. Now paragraph 3 is again the same, which talks about participation in pool and a joint business. Now, what are these some important principles? That the two alternates which we have seen is, one is the sole taxation right, wherein either the country of residence of the enterprise or the country where the place of effective management of that enterprise is situated will get the sole taxation rights on the income generated from shipping or airlines which are operating in international traffic. That is one part. The alternate B, which we saw in UN Model Convention, it said that some limited profits can also be taxed in the source state. So that is where we'll need to be very careful while we are reading the treaties. There might be some cases, there might be some instances where you will find this, and in those circumstances you will have to tax it accordingly. And you will also see that for shipping and airlines, there are certain tax law provisions which are there in the domestic tax law 44 AB, I think, and 172, which deals with certain kind of deemed income provisions in the terms of shipping business. So we'll need to see how much of that should be applicable only when the limited source taxation right applies. Also, in terms of if the ships are dealing in only in international traffic, one can always take recourse to Article 8 and say that we are not taxable in India, and therefore even the domestic tax law provision shall not apply to us. Now, the term international traffic, we have discussed it, and it is also defined in the treaty. Most of the times you will find this term to be defined in Article 3 itself. And how it is defined is, the term international traffic means any transport by a ship or an aircraft operated by an enterprise that has its place of effective management in a contracting state. Means obviously the treaty will be applicable only when the place of effective management or the enterprise belongs to one of the contracting states. That was the foremost consideration which we read, which we discussed on day 1, that the treaty benefits can be availed only and only if you are resident of one of the contracting states. So therefore it should not happen that the ship is registered, say for example in UAE, but the place of effective management is sitting in Cayman Islands. So if the place of effective management is sitting in Cayman Islands, India does not have any tax treaty with Cayman Islands, and therefore you will not be able to take recourse to the India UAE tax treaty. So one must be very careful, and one must carefully read the definition as has been provided in Article 3. Now, as per this OECD model convention definition, it says term international traffic means any transport by a ship or aircraft operated by an enterprise that has its place of effective management in a contracting state, except when the ship or aircraft is operated solely between places in the other contracting states. Now, what does it mean is that solely between is very important. What does it mean is that if there are some connecting dots, say for example, if the ship is coming from outside of India, it has touched Mumbai port and then moves on to Kochi port and then moves on to Chennai port, and in between lifts certain goods from Mumbai and then drops them at Kochi, and then picks some goods from Kochi and then drops it to Chennai. Even then, somewhere the argument is taken that it is not solely between the places in India, because the ship had come from outside out of India, and then after moving to Chennai, it will again move to certain other ports, say for example in Singapore or Malaysia or Indonesia side. So the argument which is taken many times is that it is not, the ship is not operating solely between two places of India. It is operating as a part of connecting dots between the international traffic. So there are certain, litigation which is there in these particular things, and also from an airline's perspective, this might come up as an argument. But generally, to my mind, from an airline's point of view, the license is generally not granted, but that is somewhere I'm not an expert. So we must be careful in dealing with those examples or those situations. Now then, moving on, what are the types of income which are covered? The types of income are transportation income or any directly or indirectly covered activity which is connected to the business of international traffic, or any other ancillary activity if it is earning certain income to you. Say for example, in airlines business, what happens is, which I have seen, some of the airlines will provide you some luxury kind of a treatment. They will provide you lounge access, they will provide you bouquets on arriving at the airport, and they will provide you pick and drop facility also. In those circumstances, what should they charge you an extra fee, a premium fees for providing you all these services. So what should be the case? What should be the taxation? And these kind of services income is also substantial income for these airlines. So you will find that luxury airlines, or when you are traveling in business class, these kind of services are charged extra and with certain packages name. Say for example, in the land of destination, you are provided with complimentary stay at a hotel for 2 days, or in between connecting flights for 1 day, you are provided certain luxurious stay. So all those kind of services which are being rendered for a fee, whether those should be considered as income earning from international traffic or not. So that is something which is a contentious point, and there are certain disagreements between the taxpayer and the tax authorities. So participation in pool, we have already discussed. Profits arising from alienation of ships, means if the ships are sold or aircrafts are sold, in those circumstances also the profit shall be taxable only in the state of residence, and generally it is not the source state which has got the right to tax such income. So what is the scope of profits which is generally covered? Is profit directly obtained by enterprise for transportation of passengers, profit not directly connected but ancillary to such operations. So generally airlines always take that all the ancillary services, all the luxury services or premium services which they are providing are also part and parcel of the international traffic and ancillary to the carriage of passengers and in the international traffic, and therefore it should be tax free. Leasing of ship means wet lease or dry lease. Wet lease is where you provide the ships or the aircrafts with total crew, that is wet lease, and where you just provide the airlines on lease, whether that is covered or not. Because generally what happens is, you are not, when you are providing a dry lease, those circumstances there is certain disagreement between the taxpayer and the tax authorities, that once you have provided it on lease, you are not yourself operating that aircraft or ship in international traffic. You are earning that income only from the leasing rights. So therefore, in those particular circumstances, many times you would find that such income is not covered under the scope, but taxpayers generally tend to take this position, right? So you'll have to see the language of the treaty also, that how the treaty is worded and how the international traffic is worded, and most of the times it might not get covered. Then transportation of cargo and passengers, slot chartering, inland transportation. Generally from an OECD perspective, inland transporting is covered, but from an UN model convention perspective, it is not covered. Even from the Indian standpoint, whenever you will find most of the treaties, these type of services are inland transportation is not covered. Then sale of ticketing of other operators, advertisements on ships and airlines, that is also generally covered. Container lease, maintenance and repair facilities. If you are providing certain services to other, we'll discuss one of the case studies on these particular aspect. Then there are pooling arrangements, preparatory and auxiliary services, gains on alienation of ships. Activities which are not covered is shipbuilding yard in other contracting state, or operation of hotel, means you are yourself operating any hotel, say for example a guest house or particular thing in another contracting state, and you are earning income from that, then that income should not be considered as income from the international traffic, right? So alternate B, as I mentioned, that we do not follow it. Now coming quickly to one of the case studies is KLM Royal Dutch Airlines. It is a Delhi High Court ruling. I'll quickly summarize the facts that in international traffic, what happens is that airlines are required to get their aircraft checked and technically tested before every flight. So for each of the flight, now what they have to do is they have to get a technical certificate that the aircraft is fit to fly. Now what happens is there are multiple airports, and what happens is that all the airlines cannot have their staff located at each of the airports at all across the world. So what happens is that there is an international organization which is called International Air Transport Association, which is an association of all the airlines, and all the members, what they have decided is, what they have done is they have selected certain airports, and one airline will have their staff at one location, the other will have at another location. So they have divided the work at different location. Now what will happen is, say for example member A will have their team situated at Delhi airport. Say for example 3 or 4 members will have different teams situated at Delhi airport. Now what will they do is they will check the aircrafts of all the other airlines which are flying from Delhi airport. Now for this purpose they will get a small fee, a technical testing fee for the work done by their testing team. In the same manner, what they will do is they will pay certain similar kind of fee to the other airlines which is maintaining similar kind of team at a different airport. So in a sense it is kind of one way they will be earning certain income, one way they will be expensing some income. Now expense side, there will be no concern from the income tax department that whatever you are spending, we are not concerned. But whatever income was being earned from these testing services, the income tax authorities said that this is not income from international traffic, from operation of ships of aircrafts in international traffic, and therefore this is not covered by Article 8. Now this was the case, and as per Delhi High Court, it was held that because of Article 8.4 of India-Germany Treaty and Article 8.1 of India-Netherlands Treaty, this profit could not be brought to tax in India. And they said that because these two airlines were part of the international association and they were doing pooling of business, and it was a pooling arrangement wherein they were earning certain income, which was the part of ancillary activity to the operation of aircrafts in international traffic, and therefore such income cannot be taxed in India as per Article 8. Now it also went to Supreme Court, but unfortunately the quantum of the addition was not meeting the criteria of threshold for which the Supreme Court can hear the case, and therefore it was dismissed as such. But from a Delhi High Court perspective, it lays down quite a good principle of law, and you will find some other rulings also on similar lines. So what happens now is a principle can generally be derived that ancillary activities which are part and parcel of the overall operation of ships or aircraft can also be claimed to be exempt under Article 8. Now, there are certain other rulings in SAF marine containers which said that even what happened is that the transportation had to happen from Mumbai port on a ship, but the goods were required to be picked up from Ludhiana. Now the shipping company also took the order of picking up the goods from Ludhiana to Mumbai port and then transport them to the foreign location. In that particular case, the tax authority said that the income derived for picking up goods from Ludhiana and transporting them to Mumbai are not income from the international traffic, so therefore it should be taxed. But the tribunal held that it should not be taxed because it is incidental to the international traffic and the goods are being picked only for transportation to a foreign location. So that was one. In Balaji Shipping, the Bombay High Court held that income attributable to voyage from India, slot hiring charges are also not taxable. Even from chartered ships, the income whichever is derived by the company which was based in UK, it should not be taxed in India, right? So this is one. Then AP Moller Mask said that OECD commentary and ancillary activities include leasing of ships, use, maintenance and rental of containers, etc., eligible for benefit of Article 8. So now that's what I said, that there are divergent rulings on leasing of ships or aircraft. There are certain rulings which have said that wet leasing is generally exempt because then you are giving the entire crew and you yourself are operating the aircraft in the international traffic. But in dry leasing cases, there are one or two cases, I have not been able to pick that up, which are exempt, which have said that dry leasing should not be exempt from tax. So that is it from my side. I'll now hand it over to Manoneet ji. I would be happy to answer any queries if there are any.
Can you elaborate dry leasing?
Dry leasing is just leasing of the aircraft without any crew. Okay. Wet leasing means when you are giving the entire crew also, means the pilot and the staff of maintenance. That is called wet leasing. Dry leasing means just you have given the aircraft. Say for example, Boeing gives you aircraft on lease to certain SpiceJet, say for example. Rather than purchasing the aircraft, they take them on lease, long-term lease of 10 years or 15 years. And they pay a lease rental to Boeing, say for example. Now, whether Boeing will be eligible to claim benefit under Article 8 or not. Right? Are you getting me? So in those circumstances, their case is very weak to my mind. The case is very weak. Boeing might not be able to say that I am operating ship or I am operating aircrafts in international traffic. Actually, they are not operating. They are they have just given it on lease.
I think Manoneet,
I think there are. I think we can take up queries at a later point because Manoneet ji also has some good session to go for, and we have only 1 hour. So over to you, Manoneet ji.
Andy, thank you. So I just share my presentation. Yeah, hello friends, good evening. My topic is international tax. So I will be talking about especially Article 9, when I think you have studied most of the things especially about Article 5, where we talk about permanent establishment. And what we are really talking about is how is taxation going to happen when there is a related party scenario. So before we jump into the Article 9, it's better for us to understand what is related party, what is unrelated party, and what is transfer price or arm's length price. Okay, so the way we see the concept, it really happens is when a transaction is between two related parties. In this case, it is termed as associated enterprise. When I say associated enterprises, means the enterprises are related. And when they have a transaction with any resident, a resident here means a resident is having a connection with that associated enterprise. That transaction between these two enterprises is called transfer price. And when the transaction is between independent enterprise and a resident, then it is called an arm's length price. Arm's length price is a general term which started more or less from a concept like arm's length distance. Okay, so it's like you are not related. That's how your transactions are. Okay, so and if you really see Article 9 definition now between OECD model as well as the UN model. Okay, so the definition is pretty common between OECD model and the UN model. It's an exact replica where I just read the OECD one because UN is more or less replica of that. Just the first part A and B. When we say an enterprise of a contracting state participate directly or indirectly in management, control, or capital of enterprise of the other contracting state. The same persons participate directly or indirectly in the management, control, or capital. So these definitions, enterprise, participates directly or indirectly, management, control, capital, they have been well defined in our Income Tax Act itself, especially in the transfer pricing provisions. And with regard to the second para of the same article, and in either case, conditions are made or imposed between two enterprises in their commercial or financial relationship, which differ from those which would be made between independent enterprises, then any profit which would, for those conditions, have accrued to one of the enterprises, but by reasons of those conditions have not so accrued, may be included in the profits of that enterprise and taxed accordingly. So this is a concept where virtually the transfer pricing concepts came in. I think the only exception where the UN model has somewhere is a clause 3, if you really see, which is the third part, because first two parts are more or less same. It's exactly not more or less same, exactly same, which says that the provisions of a para 2 shall not apply where the judicial, administrative, or other legal proceedings have resulted in a final ruling. So in a UN model, since it's more for the developing countries, they have kept a reservation with themselves. They have given any kind of final ruling upon it. Then they said that by the actions giving rise to an adjustment of the profit under para 1, one of the enterprise concerned is liable to penalty with respect to the fraud, gross negligence, or willful default. So they are just trying to make an extra safeguard to themselves. So we can leave that it here as of now because we have more complicated subjects to dive deep into. Okay, so now the bigger, the good point that we need to see is the OECD and the transfer pricing regulations. See, the OECD provides, because India is following up the OECD guidelines, especially for the transfer pricing purposes. And the way we have drafted our treaties is also more or less for the OECD. We have followed the OECD principle, and especially this Article 9, which is there in the most of the treaties. Article 7 and 9, which mostly talk about various sources of income and how is it placed to be dealt in. Two primary principles, I think, that now emerges from that. One is the arm's length principle. One is attribution of profits to the permanent establishment. And then there is a varying degrees tax jurisdiction around the world incorporate the underlying principles. Now, and there are now most of the countries have the domestic transfer pricing litigations as well. Okay, so the primary source of guidance as far as India is concerned is the OECD. And now we have a specific rules from 92, 92F, and Rule 10 also is elaborated for taking up the transfer pricing provisions. Okay, I've just done a comparison of earlier Section 92 vis-a-vis the new provisions of regulations, because we have treaties which have been ongoing treaties, and you can still come up with the cases which might be at a higher level of though should not be there now because almost 18, 19 years the transfer pricing regulations are there. But still you should be aware of where we were and where are we now. Okay, so even before transfer pricing regulations came in, transfer pricing regulation existed from the day one when the act was incorporated. I think the only difference somewhere was if you really see the income from the transaction with non-resident having computed in certain cases. So these provisions were very clear, which says that where a business is carried on between a resident and a non-resident, it appears to the assessing officer. So the onus was always on an assessing officer. Owing to the close connection, that the course is so arranged that the business transacted between them, produces to the resident either no profit or less than the ordinary profit. So the word here was ordinary profit, which might be expected to arise in the business. The assessing officer shall determine. So there were two onuses on assessing officer. First, he needs to determine that there is a close connection, and then as the close connection is later leading to a low profit or ordinary profits. Under the new law, that onus has been shifted from assessing officer to a taxpayer now. So taxpayer is now mandatorily supposed to prepare a documentation as prescribed format. That was only a new regulation. And ordinary profit, they have changed it to the arm's length profit. So these were the two major, you can say, the landmark changes that happened when the transfer pricing regulations came in. But if you really see the model tax convention or the Article 9 per se, Article 9 has always incorporated the principle of arm's length principle when it is there. But if you really see rule, and then there used to be rule 11, which says that if there is some business which is derived or carried out in a particular way, you go to rule 10. And rule 10 gives out a particular way of computing a profits on a basis of percentage of turnover or proportionate of profit and gain. Right? So those rules are still retained today. So if you really see when the transfer pricing regulations came in, so under section 92, they have made the two major changes. They have omitted rule 11, which used to take benefit of section 92. And now you have rule 10 is still retained. And now they have a specifically method and documentation has been prescribed in rule 10A to 10E, which has got further elaborated by the safe harbor rules or the APA rules. So I'm just restricting to the basic rules of the transfer pricing for the purpose of this discussion. Okay, so the laws related to Article 9 or attribution of profits or taxing of profits is little complicated because it is still not very defined how exactly it will operate in India. Because it starts with section 9(1) where you talk about the business connection, right? And then then there are TP regulation which came in 2001. Then there was a particular circular which government felt it was required for them to specify that TP provisions are applicable for the attribution of profits as well. Then there's a typical definition of enterprise which is defined in section 92, which will go further. And then rule 10, earlier rule 10 still also exists today. So it's like a mix of many things because international tax people doesn't apply transfer pricing regulations as it is. But I think the framers of the legislation somewhere wanted them to move towards a transfer pricing. But at the same time, they still retained rule 10, which is a ad hoc way of more or less way of making a attribution. So that we will see in a various kind of judgments also. So let me just point out quickly on the transfer pricing provisions. The reasons I am just highlighting in transfer pricing provisions, if you when we go further, you will understand that because if you really see the transfer pricing provisions also talk about these 4 basic things, right? One is when there are 2 or more enterprises. And the enterprises are associated enterprises. The enterprises enter into transaction and the transaction is an international transaction. So these are the 4 key concepts as we have seen in the Article 9 as well. So these concepts has been dealt in the Act itself. So it's important for us to understand what is the exact definition in the Act. So let's first see the definition of enterprise. It's very interesting to see the enterprise has been defined quite well in detail in transfer pricing provisions and especially also talking about a permanent establishment. there is nowhere in the Income Tax Act the word permanent establishment has been used. It's always in the treaties. But in the transfer pricing regulation, they have defined permanent establishment very clearly. So, yeah. So if we really see, the enterprise means a person's, including a permanent establishment of such person who is or has been, is proposed to be engaged in any activity. It's such a broad definition relating to any production, storage, supply, distribution, acquisition, or control of articles or goods or know-how, patents, copyrights. So it's not only PE, but any of these things you will have a enterprise, any transaction per se can create a transaction. Trademark, licenses, franchises, or any other business or commercial rights of similar nature, or any data, documentation, drawing, or specific relating to any patent invention. So most of the time you will see any company who is dealing in India, they will go and get themselves registered either in the form of trademarks or the patents or their models and design, because they want to protect themselves. So all of them somewhere creates a relationship. So whatever they do in India with that particular transaction actually creates a kind of a relationship for them. That's broad a definition as far as the act is concerned. So whenever there is a question between the act as well as the treaty is concerned, we always go to the definition which is more liberal and which is more favorable to the uh, persons who taxpayer that should be applied, right? I think I just saw one question that why there was a in the Anshul session, why the word casual has been used, because the treaties are generally written in a more documentation form where you are just dealing. It's not a law per se. It's an agreement between two treaty sovereigns. So it's written more diplomatic form by a general person's understanding, not in legal sense. But when you really go to the court of law and you have a definition defined somewhere, then it's become very difficult to come out of those definitions. So this definition somewhere actually supersede any kind of a journal word which we pick up from any of the treaties, right? So, and if the treaties define the word enterprise, courts will definitely, or especially the tax courts will definitely use this definition. And it covers everything, right? A business is carried directly or indirectly through one or more units, divisions, subsidiaries, right? So they are actually capturing everything. So we go further now. So anybody has any specific questions, so please ask me in between, because there are too many things that will flow in and out, especially because this concept of P-attribution, Article 9, and the way the profits are shared are not still very closely defined. Okay, so this is just a simple way of showing what do you mean by directly and indirectly, because Section 92A clearly defines the word directly and indirectly. If you have a just simple step-down subsidiary, that is also treated as a directly and indirectly. And if you have further, for example, relationship between A to D and D to E, and then a relationship, so all of them will be treated as a related party or associated enterprise. But Indian government didn't stop at only the three words. You might have seen there were three words here: the capital, control, and management. They have actually defined what do you mean by capital, control, and management. So, for example, they said if there is a 26% holding, that is considered as capital, control, and if there is same person at a director level at one or two entities, that is also considered as control. Sorry, that's in the management. So, and if there is an investment by a same person, is also treated as a capital. There is a loan more than 51% of the total asset. There's a guarantee. There's a 10% in the case of firm or a AOP. So these are the various ways transfer pricing regulations had defined associate enterprise. So even though we feel okay, the definition is not is only capital control and management, though Supreme Court has specific rulings on capital control and management. But since the transfer pricing regulation has came up with this specific 12 examples, how whatever they will treat it as capital control and management and different kind of activities. So this is more or less final how what will be treated as associated enterprise for the purposes of Article 9 as well. It's even if you really see, I think point number 8, which talks about 100% dependence on the use of intangible for manufacturing or processing or stock businesses. So if you're 100% dependent on somebody, right, it is still treated as associate enterprise. You might not have a direct relationship, or even you talk about direct or indirect supply of greater than 90%. If you're just procuring 90% of raw material from somebody, even that is treated as associate enterprise. You might not have a direct relationship with them because you are dependent on them. You are more or less like a captive, right? Or even procuring raw material is treated in that sense, right? Sales under the influence of the price and the conditions. Or even the HUF they have actually specifically defined. So though in overseas entity most of the time it's not there, but yes, especially in the LLPs you can still see these kind of things are also there. And the definition of, if you release or talk about one or more control by relative, definition of relative is also very broad. It goes up to 3-step level and your uncles and their sons, children, and all that level. So the definitions are also very, very broad. So that's another step. So once is section 92, which talks about capital control, right? Then section 92A2, which talks about different kind of features which we have just seen, right? Then interplay between all of these things together. So the basic, I think you can see the explanation. It is proposed to amend section 2.2. I'm just reading somewhere here. Okay, so I'm reading this third bullet, the explanatory memorandum of Section Finance Act, which says to clarify that the mere fact of participation of one management in the management, control, or capital of the other enterprise, or the participation of one person in the management, control, or capital, or both owners shall not make them associate enterprise unless the criteria of subsection 2 are fulfilled. So at least they have done their benefit. Okay, so we will not restrict to capital control and management because that will lead to very vague kind of interpretation. So that's why you go back to these specific examples and you try to see whether you fit any of these examples somewhere or not. So that is a one good thing at least they have done. But I do feel this definition itself is a very broad enough to capture, because though we have captured here only the bullet points, but if you really go to the exact language, it captures most of the things.
Manoneet, I want to ask one question.
Sure.
Can you go back to backslide? Yeah, this one. Do we need to fulfill all the conditions or specifically one?
Any one of them.
Any one of them.
Any one of them will make you associate enterprise.
One condition at a time or whole year? If suppose we have 26% share in a company, indirect shareholding, and it becomes a 19%. So can we say that this is a deemed associated enterprises?
No, deeming is a completely different concept in that sense. Okay. So I think the word deeming here written is little misnomer, because deeming is somewhere when the third party also becomes your associate enterprise. These are actually a definition of associate enterprise per se itself. Mm-hmm. So when I was saying about a part of a year, yes, when you say for a part of a year you have a relationship, that becomes your related party. Okay. And something who becomes a related party, you definitely need to share that your relationship with them is.
Even for 2-3 days, it becomes more than 26%, then we can say it is a related party.
It's a related party only with regard to, okay, so I think you need to go further for that, because it's not only a related party that per se will impact. It's your transaction also which will have an impact.
Okay.
Okay, so related party is a one thing which triggers, what really triggers is not the related party. What triggers is the transaction.
Transaction also.
Okay, yeah. So if I really go back to this definition, right?
Yes.
So one is enterprise, one is associate enterprise. So one enterprise is trying to define what do you mean by enterprise. So license office, you are talking about, right? Project office, any kind of small enterprise, or which even if you say PE is established, or even if it's not established, right? That becomes enterprise at least. Then is associate enterprise. So most of the time, if you really see, we do see the international tax litigation, we try to step away from a definition of a P itself. If we don't have a permanent establishment in India itself. If you don't have a P in India itself, then you don't need to get into the act of what you say, the profit attribution, or at least the arm's length price, because all these things will trigger at a later date. So, then you, because once you have a P, then the transaction is definitely there, right?
yes.
So what you're really talking about for 2 or 3 days, you might have associate enterprise, but you might not have a transaction. The transaction entered after once you have a relationship.
Yes.
So that is not impacted.
Okay.
Okay. So, and when the transaction is an international transaction or not. When we are talking about transaction as an international transaction, though it's more related to TP perspective. So you might still have a, for example, a relationship somewhere like this, where E also has a subsidiary below it, like is just adjacent to F, and the transaction is between C and F.
Mm.
Okay.
Okay.
So obviously they are a parent of the same entity, but that is not treated as an international transaction. But if they both are non-residents, okay, so it's like a transaction between a head office and a, because head office is a non-resident for tax purposes, though it's physically located in India, right? Or our project office is located in India, and the transaction is with the head office. Both are non-resident. The transaction is also in India. Then also it's treated as a arm's length provisions triggering.
Clear.
Manoneet, I have one question. This is Anshul. I need to check whether means just as Piyush was asking, that if the two enterprises become associated for 2 or 3 days or for certain period of time for the in that particular year, whether the transactions entered into after that relationship gets over, but within that financial year, would those also be covered under the transfer pricing regulations?
So, Anshu, the answer is primarily because you need to satisfy all the conditions parallelly, right? But what we do is, for the purposes of the documentation per se, we do filing that I have a relationship, okay? And so, because see, the penalties in transfer pricing, the burden is on you. Okay, so that's what I have actually captured earlier. The burden is always on you. So if you're too sure, okay, that your transaction was completely unrelated, then definitely you can take this call that you do not even treat it as a, because this is more a transfer pricing question, then you might not go ahead with the Form 3CB and those kind of relationships. But it really matters what is the transaction per se, because it depends. If the transaction is with regard to the shareholding, then definitely it will become a transaction. Because how will you become from say 26% to 19%? If the transaction is for the shares per se, then definitely you need to report it.
Okay.
Right. So any
Manoneet,
general answer for such is that everything needs to be seen together. But most of the time we should not leave transaction only from a sale trade transaction. Right. Even capital transaction is a transaction. Even most of the time, zero payment transaction is considered as a transaction. So, for example, if I go back to something basic thing like a copyright, patent, know-how, trademark, right? Most of the time, you will have a trademark. You will working with them, right? You have a trademark registered with them, so that there might not be any payment for that trademark, but that is still a transaction. So, if I, as a trader, I am importing a particular, I'm a sales agent, for example, Sony or any branded goods, and the brand name is registered. I'm exclusive trademark trader, and then I start trading something else also. So I still can become a associate enterprise. If I have, for example, given somewhere my address for registration or something, So we need to be very careful, especially when we are really taking anything out of this ambit of associate enterprise, because the penalties are huge. And the penalties are huge primarily because of this reason. Earlier it was on the AO, now they have actually shifted the burden on you. Right. So that's why I started with this. The provisions from old provision as a new provision is the shifting of the burden. Since the burden is on you, you need to ensure that you are completely out of it, and especially the documentation part of it, and give transparent about all the and taking the calls regarding whether you are out of the ambit of the transfer pricing per se or not. You can't take the you use the same word, a casual approach in that, okay, I'm out of the ambit of the transfer pricing provisions. So, okay, so meaning of the transaction. So, I think now we were on the same thing. The transaction includes the arrangement under action or action in concert, and it covers everything. This definition itself is also very broad. It covers an arrangement, whether that is in understanding, action in format, writing or not writing. So everything is covered here. Even the word transaction is so broad. See, because this entire provisions came like an anti-avoidance mechanism, right? So that's why the penalties are significant. That's why the burden on you is huge, because there is an assumption that you are dealing with a related party. There is an assumption of the law that you are doing some hanky-panky, and then you're supposed to prove that you are working with a good intention and your documents are proper. It's the other way around. Because if you really see, the title of the chapter itself is anti-avoidance. So that's itself put you in a different footing as far as the entire other act is concerned. Since anyway, so our focus is primarily Article 9. So we stick to that because my whole purpose was just to draw the similarity between the Article 9 as well as what we are in the transfer pricing, because the definitions are there in the act. Since I'm a litigator, so most of the time we see if anything gets challenged, how does the income tax department will react to it, especially at the tribunal or the higher levels. So they will try to read the definitions from the particular act, and you will not find too much support on the international literature on this. So your definition from OECD and other things will not have too much of weightage specific with regard to something which is specifically written in that. So similarly goes for the, I think, international transaction also. As I said, either or both of whom are the non-resident. It has to be between two or more associated enterprise. And then it can be any of the transaction, even borrowing or lending of money, or any other transaction having a bearing of profit, income, loss, or assets, mutual agreements, arrangements for allocation, apportionment, or any contribution or at cost or expense incurred. So earlier it was only with regard to the profit and loss account, but I think now those are also made clear. Anything even which is impacting your balance sheet or anything in your entire financial is captured in the under the ambit of the international transaction. So if you really see, I think the scope was extended. Intangibles like marketing intangibles, human capital, business restructuring, inter-corp company guarantees. So intercompany guarantees virtually is not a transaction. It's not a cash flow or inflow as such. You're just guaranteeing somebody's help work, right? Okay, that he will perform. Even those things are treated as a transaction. So that's why I'm saying even a zero consideration transaction is considered as a transaction. Anything where your rights are affected in a pure legal sense is considered as a transaction. Okay, so this is just a definition of what the transactions are: tangible property, intangible property, capital financing, provision of services, business restructuring. So the ambit is very broad. It includes everything. So even if we pick up one by one, I think we can have a whole session on this. So I'll just leave everything, I think, just here, and we can move further. And okay, so this is a deeming provision. Okay, so as I said you earlier that okay, there is a concept of deemed A. So I never wanted to use the word deemed A there because there is a concept of deemed international transaction. Why there is a concept of deemed international transaction is the transaction per se is not an international transaction. So is, for example, A parent is having a transaction, has agreement with a third party, and A is having a direct arrangement with from the third party. A simpler way to understand is that you have a Microsoft Office license between, say, for example, you are a Apple and you have a Apple and Microsoft anyway will not gel well. So you can say Sony have arrangement with Microsoft Office, they will provide Microsoft to all their people. And Sony India now directly approaches Microsoft because they will have a standard rates, right? Or Sony Pakistan will approach Microsoft. So those kind of arrangements will have also covered as a deemed international transaction. Though definitely, if you really talk in that sense, Sony India and Microsoft US or might not be related. But since their relationship is governed by a major arrangement somewhere, so that is also treated as an international transaction. So there is a little bit of a scope here where we can argue, just for argument's sake. I don't know how much you will be able to win that. Okay, if that's a international transaction Article 9 is concerned, then obviously this is not covered, and anything which is more beneficial to the session should be taken up, right? And but since this is a specifically deeming provision, unless you are able to take specific benefit because of a specific transaction under the DTA, so it's also covered. But that's a little risky position and little difficult position, but you can still explore that. Because the definition of associate enterprise under Article 9 actually doesn't cover this.
Oh, Manoneet, just one question here, this Anshul.
Mm-hmm.
In the last slide, in the determination of terms, whether the third party needs to be a non-resident also, or it can be a domestic party also?
No, so non-domestic party anyway will not be covered because then the transaction is completely happening in India. It's not international, right? Because one of the condition of transaction to be international is one party needs to be non-resident.
Okay.
So third party has to be international. Only thing I am saying is your relationship with the third party, and if you are able to use the applied DTA, you can still come out of it.
Mm-hmm. Right, right.
Those little ticklish and little technical, but definitely there can be some kind of an argument around that. Okay, so definitely we have prescribed methods. So if we really see the price, how do we determine the arm's length price? This is the fourth thing. Once you understand what is the enterprise, what is the associate enterprise, and what's a transaction, then you come to the price. Okay. So the whole Article 9 is actually about the arm's length price. And when you really talk about the arm's length price, the price though determined has to be the arm's length price. Okay. And if you have a single price, that is considered the arm's length price. If you have multiple price, then there is a two concept. One is a range concept, another is a mean concept. If the mean concept, then you get a plus minus 3%. In India now, earlier it was 5%. And if you have a range concept, it is 35 to 65th percentile. Globally, it is quartile range, so which is 25th to 75th percentile. This is a way how do we, if we can really understand transfer pricing methods as well as the Rule 10. The whole idea of keeping Rule 10 here is because Rule 10 still exists on the books, and this is one of the method which is commonly applied by the tax officers when we really talk about international tax cases. Okay, so typically there should not be any existence of Rule 10 once the TP methods were introduced. But if you really, if you remember that I have shown you earlier that this Rule 10, which is there, is still retained in the new provisions also. Okay, so we just understand the implication of the same, what kind of different implication this Rule 10 actually throws up now. So this entire concept of transfer pricing methods is based on the arm's length price, which is a separate entity approach, which as a simple approach is as simple as that. If I'm talking about one entity, say Apple India and Apple US, these two entities will be treated like they're two different entities, and the transaction between them is to be so treated that they are dealing with third party. So they don't know each other and they need to derive their profit based on whatever the transaction is, and they both need to retain their proper profits. Okay, so there are 5 methods, which is comparable uncontrolled price method, which is generally when you're just comparing the two prices, the transaction you can just compare. Resale price method is a trading method, which is mostly used when you are just importing goods and selling it domestically. Cost plus method is generally for the services, when the services are pure on a cost plus basis. But this method is not applied because the gross margins, this is applied on gross margin basis, and especially the resale price method also. And the gross margins of a service and a manufacturing companies are not available. The cost plus method you generally will not see in India. Profit split method is generally used either in the case of international tax cases or in the case of intangible. TNMM, I hope most of you might have heard about it, transaction net margin method. This is which is generally applied at the in the today's scenario in most of the transfer pricing cases, where you derive the net profit margin of a particular company and see the comparable companies if they are having a similar method. These other methods were earlier not there, but later on it was introduced because especially for the purposes of valuation and other things, because in the valuation DCF and other methods are used, which was not captured here anywhere. So they have kept another method. Okay, let's keep other methods also, because that gives a window of officers to use any other method also. But this window is now more useful now because there are Rule 10. Rule 10 talks about 2 or 3 specific methods, how exactly you will determine a particular transaction, which was earlier there before these transfer pricing methods came in, which is a non-transfer pricing method, which is a non-arm's length method. I will not say transfer pricing, non-arm's length method, which generally follows a unitary or a global formulary apportionment method. So how does a arm's length approach and a global formulary approach are different? So it's, if you really see, it's more or less from a separate entity approach or a unitary approach. Separate entity approach is you will treat okay, Indian entity and obviously global entity or the China entity, all these entities are separate entities and each will make their own profits. But unitary approach somewhere feels okay, no, they are all part of the same group and we will apportion some part of their profits to India. Okay, so unitary approach has its own pros and cons. Definitely you will get to tax more, but in a situation like COVID, you will not get to tax anything. So I do see people will move towards arm's length approach now because they will feel Rule 10 methods can, unitary approach can be harmful for them, at least for tax officers going forward.
Manoneet,
yeah.
We have one question from A. Rajagopalan.
Yes.
Which method is to be followed for merger and acquisitions?
That will still depends on the transaction. So this is the reason actually I kept this slide because there's so many methods now. Okay, so if you really see this method, so the problem of attribution of profit is the government has made different kind of methods for everything, depending upon approach to approach, right? So one is profit attributable to operations in India are taxable in India, right? The main problem, absence of statutory guidance. So the way I have actually said earlier, so you will have a TP regulations which says that arm's length is the principle, but at the same time you have retained Rule 10, which is a pre-arm's length regime. Okay. Then, as you see in my, I think, middle box, they are also talking about taxation based on profit determined as per India-centric books, or presumptive taxation like 44B, 44BB, 44BBA, right? Those are all presumptive basis of taxation. These are also all international transactions. So it's actually is a mix which is going on. And if we really talk about mergers and acquisition per se, it will still depends on the transaction. Because the only thing is a merger acquisition will make them a related party. And I think the transaction that we need to really see how is it gets done. Because most of the time in a merger or acquisition, the books gets consolidated and the returns are refiled. So the transfer pricing per se is not applicable in that sense. It depends how do you actually merging it. Because you consolidate everything, right?
Practice is generally followed in market as per the practice.
Sorry?
In this merger and acquisitions, which practice is mostly followed in methods.
No, that's what I'm saying. So it's not a method driven, it's more of a consolidation of the financial that really happen.
Okay.
So what really happens in a merger is that the two companies' financial get consolidated, right?
Yes.
When the financial gets consolidated, and mostly it's only applicable when you have a transaction between resident and non-residents.
Exactly.
Right? A merger of overseas entity in India is obviously through only acquisition of shares.
Yeah.
Right. So if you don't talk about two Indian entities merging, then obviously transfer pricing doesn't get triggered.
Okay. And
otherwise, their earlier approach only will apply as it is. Whatever their earlier approach would have been, the way their transaction with their overseas entity. Only thing that needs to be benchmarked somewhere is their shareholding. So if overseas entity merge with one particular entity and they have a funding which is being made, that only needs to be benchmarked, right? For which majorly a DCF method is generally used. Okay, so the biggest problem, I think, obviously we have a problem in the legislation. We have the various kind of approaches from time to time, or you can say we have a patchwork which generally keeps on happening, especially with regard to taxing of the international tax is concerned, especially if you see all this kind of presumptive basis of taxation, because the comment keep coming with different kind of schemes, right? So there is no clarity as such, and which leads to a different kind of a judicial approaches, which makes it's a more complex subject as such. So if I really talk about...
No, Manoneet, can I add something to it?
Yeah, please.
I would like to add something, because on a practical standpoint in mergers and acquisition, what happens is that there is generally, whenever the transaction is happening between, say for example, Indian resident and a non-resident, then you might require a valuation report from a RBI standpoint. Or if there is a transaction between two non-residents also, from an income tax standpoint, you might need to withhold certain taxes, and therefore a valuation report might be needed, even though RBI does not prescribe that for non-resident to non-resident. So what happens generally in practical terms is that other method is used in those kind of circumstances, because there is no other way. The traditional method or the the modern methods which were listed, the 5 methods, are not able to justify the valuation of a share transfer, which is generally happens in a merger and acquisition transaction. Or even if there is a swap of shares, say for example 2 entities in India are merged, and there is shares of old entity gets extinguished and the shares of new entity are issued to the shareholders of the old entity. In that situations also, there are valuation reports to value the shares itself. And in the Form 3CB and the transfer pricing reports, generally what we do is we write that other method is being used, because none of the 5 methods prescribed is able to capture the valuation, the arm's length basis of these transactions. So that is how generally we do it. Manoneet, please let me know if you want to add something to it.
No, so I think Anshul, that is quite good for filling in, because that's how basically we have these other methods. That's, I think, the reason I mentioned specifically for valuation and other purposes, the DCF and other things, the other method came in, because the whole purpose of this other method was to capture this valuation exercises, because all these merger acquisition generally do have these valuation exercises being done. And that's virtually is captured in the, especially the other thing where these other methods are used is this one, importing of the capital assets, right? Whenever you import a capital asset, that generally doesn't fall in any of the method, and then you need to use the other method. So I do see that I think there was another question with regard to use of the unitary method, unitary approach. So basically Rule 10 is a unitary approach, right? Where the formula apportionment is happening, and there's a whole lot of judicial precedents where this is there. So it captures is more judicial precedents are purely on unitary approach, because that is more or less either ad hoc or on a specific way of allocating global profits to India. Now, second, we are really talking about a based on the FAR. FAR means a function, asset, and risk, which is a transfer pricing method of arm's length price. Because what you really see is you do a functional analysis, asset based, what are the assets employed and what the risk assumed, and you do a similar comparison with the comparable companies, and then you make do a proper comparable analysis, and then you try, for example, if you're using a TNM method, then you derive your net profit and you derive their net profit, and that's how the adjustment is being done. Okay. And then there was a CBDT, there was a committee which came up with a couple of approaches also for the profit attribution, but at least that's not there so far. So I will not discuss that and at least confuse you further. So let's go to the profit attribution mechanism as such. So if we really talk about the profit attribution mechanism, okay, so one is based on the FAR, which I just said. So Morgan Stanley Supreme Court is the one which really talks about the this particular mechanism. If the arm's length, you have been remunerated arm's length price, nothing more can be attributed, right? And then there is a case of Hyundai Rotem, which really is a good decision where I was also involved, where everything was discussed in detail, especially the old laws and the new laws, whether the old laws still survive when the new laws came in. But there's so far is existing on the book, we can't say it's irrelevant. But yes, we understand the intention was to introduce the arm's length principle, but they are still existing. And now, since at that point of time, other method was not there, but now you also have other methods. So those somewhere are inbuilt in the system now. So presumptive and ad hoc attribution is the most of the time is the attribution which is being done, right? So they will do something on a very ad hoc basis. I will just quickly go take you through the cases also, which are just captured in the subsequent slide. And proportionate formality apportionment is you derive some kind of a formula. It's more or less like based on the FAR analysis, right? But it's like a profit split method. So if you really see this use of profit split method is more or less that kind of method where you are just using a different kind of function and asset and trying to see, okay, which thing you will make it as a base to split your profits. So you are just using that method for splitting of your profits. Formulatory apportionment in that sense was an old method which used in America before the arm's length concepts came in. And they majorly used to either use the employees which were employed or assets, which was, for example, in the real estate company, they will use the assets, or in a service company, they will use the employees as a base. So they used to split the profit on the basis of that particular, any one of the factor. So that is somewhere is used as proportionate or a formulatory apportionment method. So if I really talk about the case laws, for example, Rolls-Royce, there was a they attributed around 35%, which is pure ad hoc basis, right? So they said it will be 50% we will give it to manufacturing, 50% to R&D, and 35% to marketing activity. And if you really see what is Rolls-Royce PLC, they are making the Boeing jets. So how a court came to a conclusion you require 35% marketing activity effort for a Boeing jet engines itself is a big thing, because there are only 2 companies in the world which are manufacturing that, right? It's not that it requires a very, you will have a huge marketing team which is running around. There will always be a managing director who will be negotiating the deal. So, but still that's an ad hoc way of using 35%. And this became more or less kind of a benchmark for the entire industry, because 35%, 30 to 35%, or even for that matter, 40% in some extreme cases. So which you can just see in the lower case. So which is being used for allocating a proper kind of profit to India. And if you really see, other cases are say 15%, 10%, and even for that matter, Formula One, which was just a 2-3 day event. I think the global profit which was made attributed to India was around 56%, because everything happened in India. They said because the entire revenue was derived from India, so there was a huge share. So around, this is the only case, but this went till Supreme Court level, and Supreme Court actually upheld that. So it's around 56% of that derived based on the profit contribution analysis they have done. So it's like a more or less of transfer pricing mechanism they have used, but only on that basis they are able to drive everything to India. Similarly, in the case of
sorry to interrupt. In the Formula One case, was this 56% something which was offered by the taxpayer by doing their own study, or was it something which was derived by the assessing authorities?
No, so it was more or less derived. So, and this was the kind of, I think, is a middle formula that they have actually achieved in, but this was derived. So earlier there was entire plea was, if you really see it need not be taxed, because the government wanted to tax each and every player when they are in India, and the entire event needs to be taxed. And this is the final thing which they have actually won at this level.
But I think the entire event got transferred out of India because of this. The impact of that decision is that the Formula One has stopped in India.
Yes. So I think they were not expecting that to be get taxed, but finally they got taxed. And
I think the circumstances were different, because this ruling came out quite a later in point of time, but the event had stopped even after just 1 or 2 events. I think there were only 2 races which happened in India. That's what I can recall. But this ruling came in after a lot of time. So probably, to my mind, the ruling might not be linked to the stoppage of race in India.
No, so really what happened is, Anshul, they actually applied for that authority for advance ruling, okay, for all of them. That's the reason it went pretty fast. So it's not that it went because of that. So advance ruling was against them. So they had a fair idea of how it is going. So at the time when the races were happening, I went to see the races. There was an advance ruling which was going on. Okay, so by the time the advance ruling came, by the races were happened, so there was advance ruling already against them. So I think so they get a fair idea of how exactly India is going to treat them. I think then they waited for a couple of years to get the things cleared, because the taxation was not only for the Formula One, but it was also for each and every player, their entire vans, etc., everything. So that itself was a big issue.
Just to add, Manoneet, sorry, Gaurav this side. Rolls-Royce, there was this issue whether the transfer pricing study and the arm's length price offset the attribution of profit. So in that case, the matter went against the assessee. So there was already an arm's length price being paid for the activity. Still, the High Court upheld 35% attribution in addition to the transfer pricing attribution.
Yes.
That was
That's
quite
what I'm,
different ruling on as such.
no, I know. So only thing, I think, Gaurav, that's what I'm trying to say. Ki, since there are so many different ways the things are being done in India, so somewhere the courts are also confused what to apply, whether to pick up the TP study, whether to pick up the ad hoc ways of taxing. So the only point of highlighting all this is is ambiguity, and this ambiguity is leading to different kind of positions, right? And everybody believes whatever they're doing is right. So it's, if you really see, it goes from, I think, if I see, I think the Rotem was 9%. It's from cost plus 9% to, we have seen around 56% of profit share getting taxed in India. So it's, everything is happening. So there is no fixed principles and rules. So the advice to all the, obviously, practitioners or to all the audience is that they need to be very specific about the facts and documentation, because if you don't give a proper documentation, then any ad hoc principle can be applied, any common sense principle, and then it becomes very tough to defend that at a later date. So since I think we have already just crossed the time, so I just take one specific example for I think attribution of profits to the P, right? So for example, trade company has a core business of procurement and sale of goods in country S. So procurement, we can treat it as India, and sale of goods in country S is the overseas country, because India is majorly a procurement hub, right? By company, a related company performs procurement activity on behalf of trade company from unrelated parties in country Y. It does not own at any point of time, nor has entitled to that amount charged by trade company from its customer. The trade company pays a commission as a percentage of cost of purchases made by a buying company on its behalf. The trade company has a P in country Y as a buying company habitually concludes a contract on behalf of trade company for procurement of goods. So the answer to this is difficult, but we actually kept the answer more or less on the basis of the first step is to conduct a detailed functional and the factual analysis by recognizing the internal dealing between the P and the head office, right, as a separate transaction. So definitely there can still be an argument that P and head office are the part of the same enterprise, and obviously that doesn't require they don't be treated as an associate enterprise. But since we have seen P is being defined separately, so in the enterprise itself, so definitely that will termed as associate enterprise. The functional and factual analysis show that the trade company is performing functions of sale of goods to the third party customer in the country as. Then the functional and the factual analysis show that the P is performing functions of purchase of goods from unrelated suppliers in country Y. Further, it is also performing significant function relating to inventory in country Y. Right. So if we really see the attribution now, which comes in the last step, as a step 2, the attribution is done by applying the arm's length principle to the transaction between P and the head office. So the appropriate attribution would be at the price the trade company would have to pay if the purchase of goods is with the third party. So the core principle of the arm's length principle is how a third party would behave in that scenario, and we try to make that situation in more or less similar way. And if we are not able to make the exact situation in more or less similar way, then we try to make certain adjustment and try to bring that transaction closer to each other. That is how the transfer pricing principles are generally applied. So Piyushi, we can take up questions now.
So Manoneet, this is Anshul, just one question. So
Yeah.
I think there are certain case laws which also say that if the agent operating in India has been remunerated at an arm's length price, then there will be no separate attribution which will be required, which was the
True.
Morgan Stanley case, or some other cases also, Set Satellite, which was there.
Yes. So that's what I said. If you really talk about profit attribution, all these 3 approaches are happening in India.
These 3 approaches.
Yes. So So which I think courts and everybody is deciding whichever way. So I can't say which is right or which is wrong. If you ask me as a transfer pricing person who spent so many years in transfer pricing, I say anything based on the FAR is the most appropriate approach. Or if the second best approach is a proportionate or formalistic apportionment, ad hoc anyway is not a right approach, right? But yes, the way the rule 10 stands, you still can fall somewhere between the ad hoc approach or a proportionate approach.
Okay, Manoneet. Rohit has asked a question, when is unitary method used?
I think that I captured because I just saw that link somewhere.
Okay.
If Rohit needs a certain clarification, I think he can switch on his mic and ask. Not me.
I think we won't have any other question in chat box.
Right. So I had also responded to the questions which was raised for my session on the chat box itself.
Yeah, as I've seen.
So if the participants have any further query to the session related to immovable property or section 8, I would be happy to answer them. Okay, great. I think we are done for today. It's great on a Saturday evening to have so many participants joining in, although we are less than what we had registered for, but it's always good to have all these participants. And we'll look forward to all of you joining in tomorrow as well. We will be discussing the taxation of dividends, and it will be interesting discussion because the dividend taxation has gone for a change this year. So it becomes all the more important to understand the nitty-gritties of Article 10, because otherwise in earlier years we were always paying dividend distribution tax, and we seldom used to look at the Article 10 provisions. And then we will be discussing the provisions of Article 11, which deals with taxation of interest income, and then we will discussing Article 13, which talks about the capital gains. So Article 12 is a lengthy article, and also it requires lengthy deliberations. So the next weekend is particularly reserved for Article 12. On Saturday, we will be dealing with royalties, and on Sunday, we will be dealing with fee for technical services. So look forward to your participation, continued participation, and have a good evening, and bye from my side. Thank you, Piyush ji, for coordinating this session.
Yeah, Anshul, can you drop a topics article which we will be discussing tomorrow?
I will. I think you have already dropped it in the WhatsApp group.
Yeah, I dropped for today's session.
Wasn't it there for tomorrow's? Ashish Agarwal?
Okay, yeah, tomorrow Ashish Agarwal. Okay.
Yeah, you have already shared this.
It was already, it is already available in the WhatsApp.
Yeah, we will be discussing Article 10, 11, and 13.
Yes, right? Absolutely. And this will be an interesting discussion. Sure. Okay. So Mr. Ashish Agarwal from Kolkata will be joining us tomorrow, and he will be deliberating upon this session. Okay, goodbye, good evening.
Thank you, everybody.
Thanks, Anshul. Thank you.
Bye, everyone.
Thank you.